So direct marketing has been a very popular tool for people to increase their sales. I think we all grew up with it. In the old days, we had those Reader's Digests and sweepstakes envelopes in our post boxes. And then when cell phones arrived, we suddenly started getting spam SMSs. And I think a lot of marketers really rely on this marketing technique, hoping that it will increase their sales. But things are also changing, and laws are becoming stricter, and more often than not, the laws don't really like this kind of marketing anymore. So this morning we're going to chat about direct marketing, what it is, what the laws say about this, and how it will affect marketers going forward. So Jenny, what is direct marketing?
Well, it's really just any approach that is made to a consumer with a view to selling them something, either in the form of goods or supplying them with services. It can happen either in person or through some electronic communication, or it can also be a request for a donation. So those endless telephone calls that you get about people asking you to donate things, that will also fall under the general ambit of direct marketing. I do think that it's become a little bit of a black sheep. I think that the increase of spam has meant that a lot of people automatically associate spam with direct marketing, and so therefore they think all direct marketing is bad. But as Danie mentioned, I mean, it certainly isn't. A lot of marketers find it a very useful tool. First of all, it's cheap to do, and even if you send out 50,000 emails and you only get 4 people that buy, it's better than nothing at all. So at the moment, it's regulated by 2 different formats. The one is through legislation itself, which is through the Electronic Communications and Transactions Act, which came before the Consumer Protection Act. There's been some criticism about those laws, and I think Danie, when he talks about POPI, will just show you how it's tried to sort of cover some of the holes, and whether or not it's done that is sometimes a bit debatable. Then we also have a bunch of self-regulated bodies which have their own sets of regulations relating to direct marketing. Those are the ASA. I don't know, I mean, I'm sure you've all heard that the ASA was liquidated at the beginning of October. It has had its own appendix dealing specifically with direct marketing. So there've been a lot of our clients are asking us questions about, is it still relevant? Then there's the Direct Marketing Association of South Africa, which has its own code and ethics. You can find it on their website. And then there's WASPA, which is the Wireless Application Service Providers in South Africa. So they all have their own set of rules and regulations that deal with direct marketing, and their members, so the members of the DMA, sort of undertake to stick with those codes. And they generally are all on the same level. So at the end of the day, I think people often say, well, what is the difference between spam and direct marketing? They're the same, but they're different. In kind of like, to try and unpack it, I don't know if any of you were familiar with the wonderful Monty Python series called The Flying Circus, when they did a skit many years ago, well, not so many for me, but for you, probably not in your lifetimes, on spam. And of course, it came from Specialized Meat American Products, which is actually what spam is. It's an actual meat product. So a lot of people sort of suggested that maybe spam is exactly what spam is. It's just this continuous supply of junk mail. But it's generally taken on the form in the last couple of years of more electronic communication. I think people feel bombarded by constant offers of a variety of things. And of course, then there's also the negative aspect of spam, which has a slightly criminal element to it too. So how does it differ from just general unsolicited communications? Most unsolicited communications are just basically those emails you didn't ask for, things offering you stuff. They can be a form of direct marketing, but they needn't necessarily be. I mean, I think people find that when you open up your inbox in the morning, you'll find a whole variety of emails offering you all sorts of special offers and deals. So many of those would fall into the direct marketing category. So how is this really regulated in South Africa, and where are we at the moment? So if you ever try to explain cricket to a person who doesn't know the game at all, or somebody who comes from a country like France, for example, then you explain about there's a team, and if you're in, then you're not out, and if you're out, then you're no longer in, and if you're in and you go out, then you're out. It's kind of similar to trying to explain the aspects of the regulation of direct marketing. So currently, everybody is in, although you have to opt out. Okay. This is going to change, and Danie will take you through the explanations of that. But in essence, what that means is that the Electronic Communications and Transactions Act says that everybody can receive unsolicited commercial communication unless you specifically say that you don't want to. And how you are allowed to do that is you are allowed to say to the person who is contacting you or emailing you, please don't, I'm opting out. Please don't contact me anymore. Then you can also say to them, where did you get my details from? And I challenge you to find somebody. Maybe the scrupulous marketers in this room won't engage in that kind of activity, but I encourage you to find someone who actually tells you. Normally they say, what's the famous excuse? Your bank, or who?
Yeah, the bank.
So yeah, your bank gave me the details. So the CPA has a similar position. So it gives you the right to opt out, and it also envisages in time that there will be this do not contact list. Now that list has not yet been established because, of course, it's got to be established in terms of the legislation. Currently, what you can do is you can register yourself on the DMA website. They have got a national opt-out register where you can register yourself, and I have done that, and I can tell you that does work.
The CPA also says something else about direct marketing. Other consequences.
Oh yeah, so one of the consequences are that if you've purchased something through direct marketing and you don't want it afterwards, you've got a 5-day cooling off period. Okay, it might be more complicated where services are involved, because I'm not sure how you envisage the return of
something that you've already received.
or the services haven't yet been rendered and you've had a change of mind. But a lot of people, when the CPA came out, were a bit confused about whether or not the cooling off period applied to all consumer transactions, but it doesn't. It only applies to goods that have been purchased as a result of direct marketing. So, Danie, just to take us one step further, and the panic that arose in Europe in about April 2018.
So the GDPR took effect in May this year. It's a European law, and I need to really make this clear because there's still a lot of confusion amongst people and businesses in South Africa thinking that they have to comply with the GDPR. It's not a South African law. The South African Parliament didn't write this. It only has limited effect in South Africa, and that is basically in two situations. So you only need to worry about the GDPR if you're in South Africa. If you market your goods and services to people who live in Europe, that's the first thing. So you direct your marketing to people in Europe. Or secondly, if you monitor their behavior. Now, we're not talking about CIA kind of stuff here. Monitoring behavior happens, for example, if you have a website that has that cookie function enabled. If it tracks people's behavior on the website using cookies that gather personal information. So you get anonymous cookies that just says someone visited the site and they looked at that portion of the website. That's an anonymous cookie. So then you do not have to worry about the GDPR. But if your website uses cookies and it processes personal information, so it stores your phone number or your name or your address or one of those things, then you're actually monitoring people's behavior in Europe, and then you have to comply. Now, the odd thing though is that even if the GDPR then applies, you're obviously a South African business. So I don't know if Europe is trying to show its muscles and now try and enact worldwide legislation, but if you're in South Africa, you're not subject to EU jurisdiction. So how have they tried to resolve that issue? They say, well, if the GDPR applies, then you have to appoint an address in Europe so that the regulator in Europe can then take you to task. So I'm not quite sure how many people will voluntarily now go and submit to jurisdiction and say, here I am, I want to comply with GDPR, so sue me. But that is actually what the GDPR requires. It's a bit of a chicken and egg situation. So it says when it will apply, but it can only apply if you have an address there where they can actually make the GDPR applicable to you. But it can also become applicable if you have an establishment in the EU. So for example, if you have an office in the EU, if you're partnering with someone in the EU, so if you have a joint venture or you own shares in a company in the EU, then you have to be careful because then you might have been established in the EU anyway, whether or not you chose an address in the EU. So it's an odd one. So technically speaking, some companies in South Africa do have to comply with the GDPR because they definitely market their products and services in the EU. Many people attend trade fairs there and exhibit their products. They send marketing material to people in Europe, and then the GDPR applies. The other question that people always ask is, well, okay, how exactly does this work? So the GDPR says if you market products and services to people who reside in Europe, so we're talking about EU residents. So a lot of people were concerned that if they employ an EU citizen and they work in a South African office, that they then have to comply with the GDPR. They actually don't, because that person is a citizen, yes, but they're not resident in Europe at that stage. So you don't suddenly become subject to the GDPR if you have someone in your office or in your university, for example, that is an EU citizen. So the GDPR doesn't become applicable that way. So you have to do something that happens in Europe to European residents, to keep it simple. So there isn't a reason to panic unless that is the case. And then even then you'll have to decide, am I not going to now appoint an office in Europe to get myself into trouble voluntarily. So if the GDPR does apply, it basically works on this basis. You can send direct marketing to people only if they've opted in. It has to be very clear, express consent kind of processes. For example, you can't just assume that someone has opted in to receive direct marketing just because they've done a transaction with you. You can't just have a pre-ticked box. You'll have to actually let them tick the box to say, yes, I want your spam.
So everybody is out unless they want in.
Exactly.
There we go.
But now the GDPR becomes very complicated also because under POPI and the GDPR and most countries' data protection laws, they allow processing on certain grounds. So a similar ground that we also will have in South Africa once POPI comes into force, you are allowed to process someone's personal information if it's in your own legitimate interest. So what some marketers in Europe have done is they've said, okay, we're not going to go through this process to request everyone's opt-in, because what happens if no one opts in? Then we're going to have a big problem. So what they've decided is they're going to say, well, we're not going to request an opt-in. We're going to just argue that we are allowed to process these people's personal information in order to send them direct marketing material by arguing that it's in our own legitimate interest to do so. I think that's a very brave position to take because, yes, it might be in your interest to drive sales, but you have to balance that against people's privacy rights, and you don't really want to be the poor person or company that ends up losing that battle in a court in Europe. So the safest position in Europe at the moment is to let everyone opt in and only send direct marketing material to them if they've opted in. So that is in a nutshell how it works in Europe now that the GDPR has come out. So the future position in South Africa will be different. As Jenny mentioned, we have the ECTA and the CPA, which basically allows direct marketing to go out to everyone unless they've opted out. POPI will change the position. Under POPI, it moves from opt-out to opt-in. Under POPI, you will only be allowed to send out electronic communications for purposes of direct marketing if they've opted in. In other words, they've asked for the spam. Secondly, you can also send direct marketing material to people if they are existing customers, and that is a direct marketer phoning, which brings me actually to a good point. So under POPI, it only regulates direct marketing where you send out unsolicited communications that are electronic. So we're talking about email, text messages. It doesn't apply to phone calls, for example. So this causes a lot of confusion now. So POPI regulates this on an opt-in basis if you do direct marketing by way of electronic communications. You're sending out emails, you're sending out text messages. If you do a phone call or you hijack someone in a mall and try and sell the product, that is not direct marketing by way of unsolicited electronic communication. A phone call, I suppose, is electronic, yes, but it's not included in the definition. So what this basically means, and it's similar to the position in Europe, a lot of direct marketers will in future turn to non-electronic direct marketing. So they'll phone people, or they'll send snail mail to them, or they'll hijack them in a mall and try and sell the product to them, because those will still be regulated on the opt-out basis. So it's very confusing. So when it comes to electronic stuff, emails and SMSs, you'll have to make sure that you only send them to people that have opted in. In all other cases, you're allowed to send them until they opt out. What you also need to bear in mind is that if you want to do it on the basis that you're sending communications to someone who is an existing customer, you can only do so if you got their details in a transaction for the same kind of goods or services that you are now trying to market. So if you're an insurance company and you sold insurance to someone, you can't now contact them tomorrow to sell plastic containers to them, because those aren't similar goods and services that we're talking about. Also, the opt-in must be requested in a very specific manner. So the regulator brought out draft regulations, which is a problem, because the draft regulations say that if you want to request this opt-in, you must send someone a form. It's a 3-page form. Go and have fun and look at that form. They've copied and pasted sections from the Act. It's almost in Latin in the age of plain legal language. So the regulations, and fortunately they're still draft regulations, and hopefully you've objected to those regulations, because the time period for public comments has now closed. But it's literally a 3-page form quoting sections from the Act, quoting definitions. I hereby give my consent to receive direct marketing. It needs to be then scanned in and sent back. We live in the modern world, and we have a regulator, yes, we have a regulator that's still in the snail age, requiring you to fill in a form. I mean, how many of your customers will now fill in that form? I can't see this happening, but this is what the regulator thinks. I mean, we live in an era where you have an app and you tick a box and you say, yes, I want your spam. Now I have to go and print out that form, fill it in blue ink, they say. I kid you not. Fill it in blue ink, scan it in and send it back. Really, I think we must move on, but our regulator thinks that this is a good idea. So hopefully when they publish the final regulations, the objections will have convinced the regulator that that's not the way to do things. So as I've said, you can send direct marketing under POPI, but only to people that have opted in, or customers where you've transacted with them for similar goods and services. So, Jenny, what do you think? In future, how will this affect people? Will they still be able to do direct marketing?
I think they will. I think they must just be wary of what the regulations are, and they must follow them. And I think it's going to be, the hard part is going to be keeping your own records intact. So making sure that your list of people that you must not contact is updated regularly, because I think the penalties are quite high if you don't comply. But as I said, those people that are conscientious marketers and have already got systems in place that enable those lists to be populated shouldn't have a problem. And for the rest, one can just get advice. I think if you're not sure and you don't know if you're doing the right thing, then the best thing is just to ask an expert. But I certainly don't think it's the end of direct marketing.
No, I don't think so. I think we'll still have
You
lots
don't needn't feel like this guy.
No, no.
Hopefully
I do think it's going to kill some businesses that aren't scrupulous.
Yeah.
There are these
Yeah.
telemarketing kind of factories that use lists to phone people, and no one really knows where they got the list.
Either that or our knock and drop, our post boxes are going to start overflowing with special offers.
We'll have to to shut all of those post boxes or get rid of them.
Well, thank you very much, everyone.
Thank you. Thank you so much, Jenny and Danie. That's great. Okay, we have 4 questions that I'd just like to get through before we move on. First question is, if you are a South African media company with subscribers in Europe, would you be caught by GDPR and a subscription and opt-in?
Yes, so if you're a South African media company and you have subscribers in Europe, I'm assuming that you are marketing your service to people in Europe. Your decision will then have to be, are you going to voluntarily subscribe to the law? If you have subscribers in Europe, you might have an office there, then you might have problems anyway. So you'll have to make that that call and decide what is the right way to go forward. But if you decide to be prudent and comply with the GDPR, well, then you'll have to do things on an opt-in basis. I think that is the safest one. Don't try the other option that might lead to problems.
Okay, perfect. Right. Oh, this just popped up from Anonymous. Good to see the doc so animated. Yes, that's fantastic.
Passionate about the subject.
Absolutely.
So totally passionate.
Natasha from Wits says, what happens if an EU company you are collaborating with requires you to comply with GDPR in terms of the agreement you enter? Is compliance with POPI enough?
It's a very good question. We as a firm get a lot of requests from our European clients and even law firms that we work with in Europe to sign all sorts of documents agreeing to comply with the GDPR, and I suppose sometimes you have to sign them begrudgingly because many South African companies need business from Europe. So I think many of our clients have also been in this position where their counterparty in Europe has forced them to sign this. So if you have to sign this, well, contractually you're going to be bound to your counterparty to comply with the GDPR, which puts you in a difficult spot. But the second part of your question, Natasha, is a very good question because POPI was based on the previous version of the law in Europe, which was the EU Data Protection Directive. It was very similar. In fact, it was almost sort of a copy and paste of the EU Data Protection Act. So if you comply with POPI, I think you'll be sort of 79% there. It's very similar to the GDPR. The GDPR is sort of just the old EU directive on steroids now. There are all sorts of interesting new things that they've brought out. Obviously, the EU sort of keeps on updating their law the whole time, so it's much more sort of tech-driven these days. It talks about the right to be forgotten and portability of information and all sorts of strange things. So those are sort of add-ons. But I think if you have managed to get your processes in line with POPI, you'll be relatively safe. But I wouldn't sign a document saying that I agree to comply with the GDPR if I know I'm only on POPI level, because then I'm actually on sort of level B and I need to be on level A. So if you want to sign something like that, you might have to keep your fingers crossed and keep them behind your back. But I wouldn't sign something like that because it will probably contain an indemnity saying that if you do not comply with the GDPR's requirements, you have to indemnify your EU counterparty because they got into trouble. Or they got a 20 million euro fine. Just think about that, 20 million euro fine. So if you sign a document that says you'll comply with the GDPR and you don't, and your counterparty gets the 20 million euro fine, hopefully no one will get that, they could just push that back on you. So that is the danger. And there are some odd things in the GDPR that are not in POPI, and you might just get hit for one of those things. So don't just sign documents. We always try and tell people this, but we all do the same thing. I suppose we're all liars because we all have read the terms and conditions and we've understood them and we've checked them. So we all lie on a daily basis. So don't lie.
Thank you so much, Danie and Jenny. We'll just have to leave our questions there. If you'd like to get in touch and have a chat and ask more questions, please feel free to contact them after the session.